Well, the legislature started off with a very ambitious package of changes that were working its way through the legislature. And one of them was to change what was called the cliff in the child support law, which currently the existing statute provides for a reduction in the amount of child support that a parent would receive based upon the amount of time the other parent parents the children. So, for instance, if a non-custodial parent has the child for less than 10% of the time, they would get no credit. If they had between 10 and 45%, there would be a reduction in the amount of child support that they would have to pay, but not a large reduction. From 45.1% and up, then it would be a significant reduction based upon the amount of time. And what the legislation was attempting to do was to better define the break points in that 10 to 45% parenting time range, because it seems that a 10% amount of parenting time is not really comparable to a 45% amount of time, and it seemed that the reduction was too small when you're getting up to that 45% one and maybe a little bit too large at the 10%. So they were trying to smooth it out. The legislature was not able to reach consensus on that, so they did, however, appoint a task force to look into it and come up with recommendations for the next legislative session. That would be one area. Another area was they did revise and clarify how you calculate which spouse would receive the dependency and tax exemptions for the children. Under federal law, generally, the custodial parent would receive those rights unless a domestic court, such as a Minnesota district court or the circuit court in Wisconsin, would make a decision on who of the parents would be able to exercise it. Sometimes the court will say they will alternate it. Sometimes they'll award it to one parent or the other. And that's typically done to make sure that whoever is awarded that deduction can actually use it and maximize the benefit. As you may or may not know, those dependency exemptions are tied to a person's income, and your ability to exercise it tends to phase out as that person's taxable income increases. So what the legislature did in Minnesota this session, and that did actually pass and will go into effect on August 1st, was clarify and create the criteria that the court must use. And I believe it will make it a much easier solution for parents and have more predictability for counsel to better counsel their clients with regard to that issue.